Hello and welcome to Coin Lady channel. Only recently, a filing was made that could potentially take this reverberating SEC case all the way to the Supreme Court. What this file is, why it was done, and whether or not I think it signifies the case will be reviewed by the Supreme Court are all topics I'll cover in this video. This filing is fascinating and has garnered a lot of attention from the legal world, so we'll be dissecting what attorneys John D. and Jeremy Hogan have to say about it. Moreover, I'd want to talk about some major upcoming developments in the Bitcoin industry. Towards the video's end, there are two major events that must be witnessed. During the first part of this video, I'd like to talk about a document that Ripple has just recently presented to the SEC case. Given the widespread interest in this matter, we do not expect any new filings to be made. Both parties have now submitted their last arguments in support of summary judgment. To rephrase, everything relevant to the case has been heard. Similarly, since the judge was there, no extra paperwork was required. That fact didn't cause anyone to expect anything out of the ordinary. But Ripple surprisingly provided new evidence for this case earlier today, and it is urgently relevant to the Supreme Court considering this issue. What Ripple submitted was, essentially, the Supreme Court's decision from 4 days ago. In this case, timely notification is crucial. Well, I won't go into detail about this particular case. The Supreme Court basically decided that you can't sue someone unless they know what they are doing is wrong and why. It is now abundantly clear that this directly relates to the Ripple SEC case, and that the founders of Ripple should be held accountable and punished severely as a result. This is because the SEC has sued Ripple and claimed that Ripple should have known from the start that selling XRP was a violation of securities laws. Based on their actions, the SEC's lack of clarity, and the SEC's agenda to give particular projects a pass, it's clear that the agency has supplied the market with zero guidance since it began making pronouncements concerning cryptocurrencies. Ripple's knowledge that XRP would be considered a securities by the SEC is highly improbable. They made a point of saying that all ICO up to this date have been securities. Yet, they also went out of their way to explain that Ethereum is not a security and awarded Ethereum a pass, which just added to the uncertainty. They stated that every token in circulation can be considered a security notwithstanding Ethereum's previous classification as such. As a result, everyone understood that their token was no longer a security. Or, we have successfully established a decentralized system. Ethereum is the last remaining centralized network. After that, the SEC started telling them everything was fine. We also disagree that payment tokens are securities, yet the SEC later admitted that it had made claims regarding Ethereum. Yet, it's possible that has changed. Coins and tokens used in payments can also function as investments. Also, no one has offered any sort of direction in this predicament. Nobody knows what the guidelines are. No one is aware of the forbidden items. The Supreme Court has declared that you cannot file a lawsuit in this fashion without first providing specific instructions. Since there is plainly a lack of clarity in the market, the SEC cannot charge players of breaking the law when it has never been made apparent what the law is. The SEC is attempting to impose fines on those responsible. This Supreme Court ruling says it's forbidden, which is absurd. This has been discussed at length by Jeremy Hogan. He said that Ripple just provided persuasive evidence in favor of its fair notice defense, which is backed by the Supreme Court and which claims that regular people like you and me need guidance and awareness of the applicable laws before being sued. The SEC has recently become a dictatorship within the financial industry. They detect uncertainties in the cryptocurrency market and think, oh terrific, we can go declare. There is no legality to anything these people do. A recent judgment by the Supreme Court made it clear that such conduct is illegal. The SEC should not act in an overbearing manner either. What makes this situation noteworthy is the implications it could have. This suggests Ripple anticipates the case will be heard by the United States Supreme Court. In spite of what some may have you believe, this is not true. Ripple does not know what will happen next. It is also important, in my opinion, to note that the fair notice defense will only come into play if Ripple ultimately loses and XRP is ruled to be a security. If Ripple is successful and XRP is deemed insecure, then fair notice is unnecessary. Throughout the time, Ripple did what was required of them legally. Hence, in an effort to attempt to spell exactly precisely what I think would happen in this situation in the worst case for ripple effects, fair notice doesn't truly apply. I tweeted about this because I think it will help people better grasp the big picture of fair notice. Considering John D's involvement, I give Judge Torres a 95% chance of ruling that XRP is not a security in the secondary market. If this proves to be the case, XRP supporters can celebrate a major triumph. While she can continue to make her own call on when they sold XRP and when Ripple sold XRP, she can't change the fact that she has the last say on the matter. There should have been communication with the SEC about them. And this is where things start to go south for Ripple in court. Despite this, XRP traded on the secondary market would not be considered a security. In the worst situation, Judge Torres may rule that Ripple broke the law by failing to register the sales as required by federal securities legislation. The SEC now says Ripple must pay $2 billion in compensation for this. It's safe to say that sum is quite large. I think we can all agree that what Ripple was doing would have been considered a securities transaction, but they were never given a fair warning. Judge Toller would agree that the reasonable notice defense is applicable here. Nonetheless, I do believe he should have been registering the tokens with the SEC, and they never made it clear that what you were doing was wrong. As a result, everyone might assert the defense of fairness and pay only $100 million rather than $2 billion. In light of this, the reasonable notice allegation is essentially just damage control for Ripple if they lose their action to the SEC, and they should have been disclosing their sales from the start. Right now, I just don't see it happening. To my knowledge, Judge Torian has not yet ruled on whether or not XRP is a security. More importantly, I think the vast majority of Ripple sales will end up being profitable. While it is true that Ripple presents a strong argument, this does not always indicate that their case will be heard by the Supreme Court as a result of the submission. Just in case, this is the worst case scenario. Meanwhile, Ripple is always 10 steps ahead of the SEC. We're not just losing the argument that XRP is a security, but the SEC has taken notice of the issue as well. Even if we do end up getting a kid, Ripple will be able to defend themselves and cut most of our price from now on. In addition, John D added something that I think is crucial, that Ripple has much higher odds of winning its case against the SEC in the Supreme Court than it does right now. Thus, I think it's important to emphasize that if Ripple loses this case, which it doesn't appear they will, I seriously doubt it. With what John D has said and what we've heard from the other lawyers, their odds of winning before the Supreme Court are significantly stronger. Current information suggests that the SEC's position in the ongoing legal conflict is quite vulnerable. Yet, even if they do not succeed at the lower levels of court, Ripple has a fantastic backup plan to win against the SEC in the Supreme Court. In any case, Ripple accomplished the following in its filing today. This case may or may not make it all the way to the Supreme Court, but preparations are being made just in case. The Ripple legal team is vastly superior to the SEC's, whose lawyers seem to change their minds every week and haven't even settled on a position. Meanwhile, Ripple's legal department is preparing for the impending dispute by looking ahead several years. It doesn't matter if it does or not. This should show you that the legal teams we're collaborating with are competent. This causes me to think, wow, Ripple might end up being incredibly lucky in this case, on sometimes. As a result of legal proceedings, Ripple will finally know what its coin is, but the rest of the business will have to wait years to find out. They also assembled an excellent legal team to lobby for a ruling that XRP is not a security, which they expect to win. Before we conclude up, there are a few major trends in the Bitcoin industry that I think you should be aware of. We will begin with a subcommittee hearing on digital assets. The date for the sets is March 9th. Interesting times lie ahead. I can see whether anything worthwhile is accomplished during this meeting. Chief executive officers and professors from several institutions will speak before Congress on the topic of digital assets. It's anyone's guess. The sooner these preliminary hearings are finished, the sooner Gary Gensler will come before Congress, so it's good that discussions have begun. It's encouraging to see things finally moving forward, especially since this is just the first of many hearings, and probably the time when things get really interesting and Gary Gensler starts to feel the heat. Another major happening is Grayscale's March 7th game against the SEC. You'll get to hear Grayscale essentially sue the SEC for permitting a futures ETF but not a spot ETF, as this is a legal case. If they're both pegged to the same price, as I understand it, the SEC has a weak case. However, I think it'll be interesting to hear this. My guess is that it will shed light on the SEC's true intentions in trying to stifle the company. It will be interesting to see if they offer any valid justifications, because I haven't been able to find any. Nonetheless, it will be an important case for the industry overall, so we will need to keep a watch on it. Still, I value your attention greatly. I trust you found this update interesting. When you do, don't forget to click the like button and the subscribe button. See you in the next one. Bye.